5 seconds to go. Start. What is the effect of the amendment made by virtue of Act 54 of 1994 with effect from 14th November 1994 while substituting clauses E to H of section 10(2) which contained medium goods vehicle, medium passenger motor vehicle, heavy goods vehicle and heavy passenger motor vehicle by transport vehicle, whether insertion of expression transport vehicle under section 10(2)(e) is related to said substituted classes only or it also excluded transport vehicle of light motor vehicle class from the purview of sections 10(2)(d) and 241 of the Act. What is the effect of amendment of Form 4 as to the operation of the provisions contained in Section 10 as amended in the year 1994 and whether the procedure to obtain the driving license for transport vehicle of the class of light motor vehicle has been changed? The judgment in Mukund Devgan 2017 shows that the three-judge bench considered Section 221, 247 read with Section 10 of MV Act. The court also examined the legislative intent behind the 1994 amendment to Section 10, noting that while the amendment introduced the term transport vehicle under Section 10(2)(e), it did not amend the definition of LMVs under Section 221. It was further observed that the newly inserted provision of Section 10(2)(e) would only subsume those classes of vehicles that were contained in Sections 10(2)(e) to 10(2)(h) of the unamended Act, that is medium goods vehicle, medium passenger vehicle, heavy goods vehicle and heavy passenger vehicle, and which now stand deleted by virtue of the amendment of 1994. Since no amendment was carried out in Section 10(2)(d) of the Act, which contains the class for light motor vehicles, the scope of Section 10(2)(d) would remain intact as is contained in Section 221 of the Act, which is to say that LMV would include transport vehicles in cases where the gross weight of such vehicle is less than 7,500 kgs. It further noted that the syllabus does not provide separate training for transport vehicles but includes them under the relevant vehicle class based on the vehicle's weight. It considered Rule 75, which deals with State Register of Motor Vehicles, as provided in Form 41. Form 41 categorizes vehicles on the basis of inter alia gross vehicle weight, unladen weight, etc. Likewise, the court observed that Section 41 pertaining to registration mandates the inclusion of relevant information as specified in Form 20, which outlines details such as the class of vehicle, gross vehicle weight, and unladen weight, among other factors. The court analyzed those key provisions of the Act and rules and reached a conclusion which is aligned with the discussion and opinion in this judgment. It rightly concluded as under: light motor vehicle as defined in Section 221 of the Act would include a transport vehicle as per the weight prescribed in Section 221 read with Section 215 and 248. Such transport vehicles are not excluded from the definition of the light motor vehicle by virtue of Amendment Act number 54 of 1994. A transport vehicle and omnibus, the gross vehicle weight of either of which does not exceed 7,500 kg, would be a light motor vehicle, and also motor car or tractor or a road roller, unladen weight of which does not exceed 7,500 kg, and holder of a driving license to drive class of light motor vehicle as provided in section 10(2)(d) is competent to drive a transport vehicle or omnibus, the gross vehicle weight of which does not exceed 7,500 kg, or a motor car or tractor or road roller, the unladen weight of which does not exceed 7,500 kg. That is to say, no separate endorsement on the license is required to drive a transport vehicle of light motor vehicle class as enumerated above. A license issued under section 10(2)(d) continues to be valid after Amendment Act 54 of 1994 and 28th March 2001 in the form: the effect of the amendment made by virtue of Act number 54 of 1994 with effect from 14th November 1994, while substituting clauses E to H of section 10(2), which contained medium goods vehicle in section 10(2)(e), medium passenger motor vehicle in section 10(2)(f), heavy goods vehicle in section 10(2)(g), and heavy passenger motor vehicle in section 10(2)(h) with the expression transport vehicle as substituted in section 10(2)(e) related only to the aforesaid substituted classes only. It does not exclude transport vehicle from the purview of section 10(2)(d) and section 241 of the Act, that is light motor vehicle. The effect of amendment of Form 4 by insertion of transport vehicle is related only to the categories which were substituted in the year 1994, and the procedure to obtain driving license for transport vehicle of class of light motor vehicle continues to be the same as it was and has not been changed, and there is no requirement to obtain separate endorsement to drive transport vehicle, and if a driver is holding license to drive light motor vehicle, he can drive transport vehicle of such class without any endorsement to that effect. It is true that Mukund Devgan 2017 did not analyze the provisions that distinguish transport and non-transport vehicles as noted in the reference orders. The statutory scheme of MV is more nuanced than the simple weight-based distinction made in the said judgment. Moreover, the court failed to notice section 31(2) and 31(3) which specify transport and non-transport vehicles. However, the judgment gave due consideration to the important statutory provisions. We have carefully looked at the relevant and the wide-ranging provisions in our analysis in this decision. A harmonious interpretation, as we have explained earlier, would lead us to the same conclusion, but fortified with some additional reasoning based on the consideration of all the relevant provisions. The overlooked provisions would not, in our considered opinion, alter the eventual pronouncement. Importantly, we do not notice any glaring error or omission that would alter the outcome of the case. Therefore, the ratio in Mukund Devgan 2017 should not be disturbed by applying the principles of per incuriam. The counsel for the insurance company raised concerns regarding road safety, arguing that if the present law in Mukund Devgan 2017 is not interfered with, unfit drivers will start plying transport vehicles, putting at risk the lives of thousands of people. One of the sporting interveners placed reliance on para 57 of the decision of this court in Save Life Foundation versus Union of India, where this court, while exercising its public interest litigation jurisdiction under Article 32 of the Constitution of India, held that the right to life under Article 21 also includes the right to safety of persons traveling on the road. Per contra, in the intervention application filed on behalf of auto drivers, it was argued that the members of the applicant intervener have been permitted to operate taxis and motor cabs while holding an LMV license for the past almost 6 years. Stop.